Good evening and welcome to the Monday, July 25th, 2022 meeting of the Planning Commission. Iris, would you call the roll, please?
Keep.
Here. Here.
Meek.
Here.
Mitchell.
Here.
Moreno.
Here.
Phillips is excused. Rigby.
Here.
Stewart.
Here.
And Counselor Mans. I don't see her. Thank you.
In which case, we probably will not be having a council update this evening. Iris, do we have anybody who would like to make a comment that is not on, for anything that's not on the agenda this evening?
No, we do not.
Thank you very much. For Commission for Citizen Involvement update, it looks as though the Lake Grove Neighborhood Association is going to have a meeting on August 2nd from 7 till 9 p.m. at the at the Lake Oswego Fire Department, Station 211. I think that's where it's being held. So, and that's the only update I have for neighborhood and citizen involvement. Next, I guess we go to updating or approving the minutes from June 13th, 2022. Is there anyone who would like to make any corrections or additions to those minutes? If not,
I'd like to make a motion to approve the minutes from June 13th, 2022.
thank you. Is there a second?
I second the motion.
Thank you very much. It looks as though the minutes from June 13th, 2022 have been approved. Now, number 7, we're in work session for 7.1, Mitigation for Ministerial Development, work session number 1, LU 22-0031. We are accepting public comments. Do we have any public comments this evening for that?
No, we do not.
Thank you. So I guess we turn this over to Senior Staff Erik Olson.
Okay, there we go. Thank you, Chair Leek. I have a presentation that will go up on the screen in just a moment. But my name is Erik Olson, Senior Planner with the Planning Department here at the City of Lake Oswego. And I'm going to be talking today about, it's a follow-up to some of the work that we had done related to middle housing in HB 2001. And this is really talking about some changes to our process for mitigation to accommodate some of the changes that accompanied those code amendments. So I'll talk a little bit more about that in just a moment. So just in general, I'll go over a bit of the background of where we, sort of what we do today when it comes to requiring mitigation or other types of public improvements for new development. Talk a little bit about how the code amendments may have changed the process in some ways, and talk a little bit about how we determine conditions of approval for minor development. I'll also talk about a new process that we're proposing that would essentially establish a new ministerial mitigation process for us to quickly administer and determine the requirements that must be met for different types of developments upon their application. So I will get started. So I'll start with some of the background. Of course, this is something that's been around for quite a while, but there has long been a requirement that all standards related to housing, any criteria or standards applicable to housing, be clear and objective. And that's something that's been around for quite a while under state statute. Of course, there's also an allowance for cities to provide an alternative discretionary track. We actually don't see very many applications come through under this sort of clear and objective track, but we do have 2 tracks currently for residential development standards. In areas where we do allow discretionary approval, we would allow for a discretionary review track and a clear and objective review track as well. So this is for minor development that requires discretionary approval. Sort of adding to this, recently, as most the Planning Commission is well aware, just last month this became effective, our code amendments to comply with the requirements of House Bill 2001. So what this did was this permitted middle housing, which includes duplexes, triplexes, quadplexes, townhouses, and cottage clusters, to be allowed essentially in all the zones where single-family dwellings are permitted. And as a part of the requirements there, we had to allow for middle housing to be approved under a ministerial development process. And we'll talk a little bit more about what that means, but it is a more sort of simple version of the process that existed previously for these types of housing. The amendments that we have now adopted for middle housing did not include changes that would allow the city to require mitigation for ministerial development. So we essentially had been recommending that we establish a process to do so back, starting in the Middle Housing Code Advisory Committee about a year ago. We started talking about this, but it is a follow-up to allow for the city to require sidewalks, street improvements, curbs, gutters, things of that nature for new middle housing development. So our current development review processes, we have ministerial and minor development types, and I'll talk a bit about ministerial development first. We also have major development, but I'm not going to focus much on that. So different types of ministerial development include exterior modifications or construction of new single-family dwellings, duplexes, ADUs, and other accessory structures. So that's sort of traditionally what we have allowed under a ministerial track. Of course, now that we have adopted the Middle Housing Code requirements, this also includes triplexes, quadplexes, and cottage clusters, but duplexes were always allowed under a ministerial process when they were allowed. So this ministerial development process does not require a pre-application conference, a neighborhood meeting, public notice, or a public hearing. There's no opportunity for a public hearing. So this is primarily reviewed by staff. This is how we handle a typical single-family dwelling application, the building permit stage. Once staff deems it to be complete, there's a coordinated review amongst different departments, including engineering, building, planning, and fire departments. Of course, when planning reviews this, we look at compliance for zoning specifically, including your sort of design and dimensional standards and other things that sort of fall into the purview of the planning department. And ultimately, the decision-making authority here is delegated to the city manager, and that's a required term that includes staff. So that covers ministerial development. I'll talk a little bit about minor development now. So these are different types of land use approvals that we're talking about here. So this is including variances, partitions, subdivisions, lot line adjustments that increase density, historic review, changes of use, multifamily, residential development, commercial development, industrial development, and all development within certain overlay districts. For instance, the DRD, or I'm sorry, the Old Town standards are basically require minor development review, discretionary review for any development. So again, this is a more discretionary level of review. It does require a public notice. Typically, it does require a pre-application conference, and most, I'd say many, I guess not most, but a lot of them also, or a lot of different minor development applications would require a neighborhood meeting and a public hearing. So those decisions are generally subject to appeal to the DRC or City Council as well. So this is the typical process for an application that goes to the DRC, more or less, and there are other staff level decisions that can also be appealed. All right, so when it comes to requiring mitigation, I haven't talked too much about that process. When it comes to for ministerial developments, we don't have an opportunity currently within the code to require mitigation or require the provision of public improvements to offset the impacts of new development. So this is for the ministerial process. Currently, we don't have this opportunity. And so I just take this opportunity to clarify that regardless of sort of mitigation and conditions of approval that we're talking about on public improvements, all development, regardless of if it's ministerial, minor, or major, would continue to be subject to systems development charges and other fees that are designed to recompense for the development. So SDCs are applicable to all different development types and are collected at the time of the building permit issuance. So that does exist for ministerial currently. And it's applied uniformly to all new developments that would increase demand on infrastructure systems. So these aren't really intended to address the site-specific infrastructure impacts of the development in the context of its surroundings. SDCs and those types of fees aren't, at least. So that's really what the mitigation and public improvements are supposed to cover. So I would just talk a little bit about conditions of approval. Currently, we do have a section of the code that authorizes the city to impose conditions of approval on minor and major development types. So this usually happens, upon approval of a minor development application. Conditions will be included in the staff report that would be reasonably related to a few different things, either quote unquote alleviating the need for public services or facilities. So sewer, water, parks, open space, streets, sidewalks, and pathways, things like that. Or it would have to be related to eliminating or mitigating a negative impact on the built environment when those are essentially caused by the development that's being proposed. So this is something that has a lot of legal precedent. It's based on longstanding sort of legal precedent and consideration of both policy and site-specific factors. It was a more involved sort of legal analysis based on sort of a nexus. There had to be a clear nexus between the mitigation or exactions required and the actual development being proposed. And there'd have to be roughly proportional to the development being proposed. The mitigation would have to be proportional in some way. So this was established in a few different court cases. Nolan and Dolan are kind of how we commonly refer to them. All right, so that just kind of covers our existing processes for how we would ask for public infrastructure or other public improvements, as well as SDCs. I can take questions now if you have any questions about that, or I can just get going into our proposal.
So if you go back to the screen with the Nolan versus Tigard, so in that case, they wanted to, in downtown Tigard, the city, a mitigation for their development, they had to put in a walking path or something? Was that the quid quo pro?
I'm honestly, I get these mixed up quite a bit. I'm not as brushed up on my legal history there, but they are.
The Dolan case was a case of the city requiring a pathway connection adjacent to, it was I think a hardware store. And I think that was the case where,
Didn't that go all the way up?
was it reasonably related? No. And I think the city attorney can correct me if I'm wrong. I think the Nolan case relates to the rough proportionality.
Yeah, I think they're just the two cases that are kind of showing that there needs to be that nexus and rough proportionality relationship. And yeah, there was another sort of piece there, but I think that's kind of the biggest concepts that we're gleaning there. There's a lot of different cases that do this in different ways.
So in other words, what the city was requiring of them was appropriate? Is that what the nexus and proportionality terms mean?
Well, it basically said that what the city was requiring had to be appropriate and roughly proportional.
Okay.
So I'm not sure if what was originally proposed met that requirement, but that was the determination.
Okay. And that's what we would be doing also. Thank you.
Yeah, this is something that we've been using, or the city attorney's office rather, I guess, has been using to determine conditions of approval for decades now.
Thank you.
So this is kind of the, again, minor development, more involved version of the process. Minor or major development. All right, so just talking about mitigation for ministerial development. This currently does not exist.
We have
in
one
code.
more question.
Oh, I'm sorry. Apologies.
Yeah, Rick, sorry, I had a question. Is it correct then in the understanding that our current process for ministerial reviews it didn't have mitigations and exactions. And so what we're doing here tonight is that we're going to be adding mitigations and exactions to the ministerial review process. But the way the ministerial process exists today, we don't have mitigations and exactions. Is that correct?
Yeah, that's correct. So essentially, we, under our current processes, I mentioned we don't have this ability to require mitigations, even though we do have the ability to require fees or STCs. So this would allow us to require the type of mitigation that we would have required under a minor development approval for something like a triplex, quadplex, or something with that level of density and added density. But it would just be under a more ministerial or straightforward, clear and objective process.
Thank you.
Just one more question from me. So when a spot lot that gets brought into the city boundary builds, you don't ask them to put a sidewalk in because it doesn't connect anything? Or do we ask to have a sidewalk put in knowing that down the line there's going to be more development?
It depends. There are certain circumstances where a sidewalk makes sense based on the site-specific factors and context, if you will.
And so we do ask for those sort of things.
We do, and I would also point out, as part of the code amendments, we did sort of move these types of developments, triplexes, quadplexes, et cetera, into ministerial, from minor to a ministerial development to comply with state requirements. So because we changed it to ministerial, we no longer have the ability through the minor development process to ask for those conditions of approval. So this is something recent as of like this month that we no longer have the ability to do that for these
Unless we also ask for it for single-family development.
Well, conceptually, that would be the case, but we did adopt code amendments already that kind of have a set process. So we didn't necessarily go that route, I guess, yeah.
Okay, thank you.
But to answer your question, I guess, in a bit more detail, we would also apply, as we do today, we would sort of take a look at single-family dwellings. We don't have a mitigation process, but that's kind of by design, and I'll talk a little bit more about that. So we don't expect actual required improvements to change for single-family dwellings necessarily, but it will be a different process. So as I mentioned earlier, we, out of the House Bill 2001 and Middle Housing Code amendments, we ended up coming up with a recommendation to establish this more clear and objective process to allow the city to require mitigation or public improvements to accompany ministerial types of development. This is really intended to ensure that impacts on public infrastructure from the added density are sufficiently mitigated, as well as ensuring the public improvements are a bit more right-sized, sort of looking at what we can allow now under zoning, which is a lot more dense than what was originally contemplated when we planned single-family zoning districts in the first place. So we are able to upsize the infrastructure as needed here. And we're also able to comply with those clear and objective housing standards that we've been wanting to comply with for some time. And this is just would further our compliance, I believe, based on the city attorney's interpretation, deputy city attorney's interpretation. So the proposed process that we wanted to talk about today would really require that development be mitigated based on a fixed schedule that's clear and objective. So really not saying, it's a certain numerical limit, like if we have a triplex, you have to do 400 square feet of sidewalk or something like that. It's not going to be that numerical sort of calculation, but it will be just a requirement to install the infrastructure required per the applicable street standards. So it could be our sidewalk standards in the code, design overlay standards that exist, street design standards that could differ in different areas, as well as the standards that Public Works and Engineering utilize to determine the roadway design and other sort of details. So we'd only require this when a building permit application would add dwelling units to an existing lot. So, it would apply to the full range of ministerial development, and that would include detached single-family dwellings and all the different types of middle housing. But we wouldn't necessarily, based on our initial analysis at least, expect that single-family dwellings or duplexes would necessarily need to provide more than they would under our current or previous process for those housing types. But we would, again, sort of look at it at this sort of triplex, quadplex and above threshold for providing this mitigation under the ministerial process.
Is that legal?
It is. And I mean, it's more or less what we do today, but just through a different process. And it's, it's based on the anticipated impact of that development. So, yeah, there's no requirement that, we ask for the full street build out for new single family dwellings necessarily today when they come in for a building permit. But we would be able to do that for triplex, quadplexes, et cetera.
Commissioner Rigby, you have a question?
Thank you. I don't know if this was kind of the approach you were going for there, but, or if that's what you were answering, but is that legal in the context of HB 2001 in terms of not differentiating our approach between single family and middle housing?
Yeah, that's a good question, but it is based on our understanding. There is very explicit dialogue within the rulemaking for House Bill 2001 about the ability for cities to require that new development provide infrastructure for these higher density forms of middle housing if it doesn't exist. So in some ways, this was a way to not allow cities to just preclude all middle housing development for these reasons. So they couldn't just say, well, sorry, we're pretty sure we don't have a big sewer line in that area, so no middle housing there. But the city can allow it under this sort of circumstance where they provide the additional infrastructure necessary to service the development based on our standards.
So DLCD has addressed this.
Absolutely, yeah. Okay. Yeah, and there's some Q&As that talk specifically to this. We've actually, from DLC, but we've been keeping in touch with other jurisdictions who are undergoing a very similar process basically right now, and different approaches as you can imagine. But yeah, I think we were looking at other places for a bit of inspiration for what we're doing here. So there's precedent. So just to finish that thought, we wouldn't necessarily require that detached single-family dwellings or duplexes require or provide public improvements, just as we wouldn't necessarily require that today or before middle housing. But we would do that for triplexes, quadplexes, and above.
Eric, I think the premise behind that is that when lots were created, when they were developed through as a subdivision or a partition, that there was an opportunity at that time, and the city typically would have required public improvements, streets, utilities, pathways, or sidewalks, if that's what the plan called for at that time. And so those lots, single-family lots, in a sense, have been created with adequate, infrastructure or level of infrastructure to support that development. Now we're adding density through middle housing or other forms, and so I think that might be part of the thought process at the state, that it's reasonable that we would be able to do that, and it's also, it would also pass muster with Nolan and Dolan, provided we, create the findings to show that it's roughly proportional and of course related to the development.
What happens when a house on an existing lot is demolished and they build a primary structure, good size, and an ADU? Does that still fall under this ministerial?
I don't believe that, well, it would fall under the ministerial mitigation process, but our initial analysis wouldn't show that that sort of one additional dwelling unit would provide the additional trips generated to require, new sidewalks or, a certain width of sidewalk, for instance, perhaps, or a certain size of utility connection. So that's typically something that we have, at least in initial analyses, found is triggered by adding or having 3 dwelling units on a lot, more or less, or more.
Thank you.
That, and I'll specify again, to Scott's point, 3 dwelling units on a lot that was originally planned for single-family dwelling and or a duplex.
Chair Leak, Commissioner Stewart has a question.
Oh, he does. Commissioner Stewart.
Hi, yeah, so I guess my concern is, in listening to this discussion, is that, I think our city is different in that a lot or most all of the development opportunities that exist are all now infill So when you have a situation where you're replacing a single family house and it's, it's in the middle of development that's already there, maybe there is a need to impose, I guess, condition, maybe it's conditions of approval where they connect a sidewalk or something like that, or at the very least, a lot of times when you do construction work, you'll beat up the existing sidewalk. So I'm assuming there's requirements in place to replace and improve anything gets messed up, right?
Yeah, thank you, Commissioner Stewart. That's existing code, and so it's a street opening permit. So a building permit would typically have a street opening permit that is looking at the condition and making it whole at the end if it is damaged.
It wouldn't necessarily be what we would deem a condition of approval, which we only apply to minor development, but it would, be something that we would be able to require through the street opening permit, more or less.
Right, yeah, as long as I was just making sure, just confirming there was something in place like that. Thanks.
All right, if there are no more questions, I can keep going on the presentation. Okay. Wait for it to come back here. All right, so again, it would be a requirement that development types are mitigated based on a fixed schedule that's clear and objective, again, based on the amount of density being added to a site. Mitigation would only be required, again, when you're adding development units to a site. I think I already went over this slide, actually. So just to talk about some of the different street improvements that we would require, we're looking at a configuration where this would be different in different areas of the city. So we have thought about what it would look like in what we call urbanized areas and what has been defined as the rural fringe as well. So in a more urbanized area, which is most of the city, we would require curbs and gutters to be installed if they don't already exist there. If it's unpaved or partially unpaved road, we would ask that to be fully paved. And this is again for new development that we would require this for in order to upgrade the street. This is for minor development, the types of improvements that we would ask for. Public utility easements to ensure that utilities are sufficient, provisions of sidewalks or pathways, and again, the utility lines themselves, water, sanitary sewer, and storm drainage. So you can see, this is, kind of what it looks like. It looks different in different areas. There's different street design sort of standards in different areas of the city. One thing, and so that would be something that, depending on, again, those site-specific factors, exactly, which zone the development is located in, the required street improvements could look slightly different. When it comes to these areas and what we call the rural fringe, and again, this is a defined code that basically includes the urbanizable fringe and newly annexed areas. So I think we're working to sort of refine that terminology and the specific locations where it would apply. But for the most part, we're trying to cover these more rural, I guess the rural fringe is pretty evocative in and of itself as a term, but these more either partially paved or just not completely improved roadways on sort of the outskirts of the city or unincorporated areas of the city. So in those areas, we would, instead of requiring a sidewalk and a curb, we would generally ask for a pathway with a drainage swale or a gravel shoulder, things of that nature to sort of match the more rural character there. So, again, this is one way that we would incorporate those differences in the different areas of the city, but again, there are also different sort of street design standards in different areas of the city as well. So that would sort of, just kind of, it would sort of just determine the form of the mitigation in some ways and exactly what type of curb or gutter we might be requiring.
So in this, if you go back to the other slide, that's up from the post office, and there are properties towards Waluga Drive that are not curbed and beautifully landscaped like this, but as they get developed, they will have to match this?
If it's adjacent and would have to match this, I think this is actually not a, I'm not sure exactly, but I'm not sure if this is a huge connector road necessarily, but yeah, I mean, if there was development going on, I guess the east of Trillium Woods, then they would be required to provide similar public improvements, if not the same. This was approved under, I think, a planned development process, so it was more of a,
But shouldn't
designed
the
community.
same flavor be continued?
Well, I mean, that would be nice if we could just, require them to keep all the design standards, but the city has their own design standards that we can require, and they might have gone a little bit above and beyond in certain areas of the city.
I see.
But, yeah.
Thank you.
But for the most part, the intent is to expand it in areas where it makes sense, not just have these islands of, disconnected sidewalks in areas where that really doesn't make sense. So, it's one of those things where, there might be areas on like Noss Road, for instance, where at one point there was just one side where one, newly annexed property, and it didn't make sense to ask for a sidewalk, but it reaches a certain threshold where, it makes sense to start putting in a sidewalk. So, I guess I would just point out that typically in those circumstances, even if we don't ask that they provide a sidewalk, we typically ask that they invest or make a contribution to an LID or a local improvement district to basically recompense for future infrastructure that could be constructed by the city in that area. So that's our current practice. And
local improvement districts it's a rare occurrence, that the city creates one, or the property owners, because it has to be through a vote of the property owners to assess themselves. But it is a good tool, and in these fringe or rural fringe areas, it can be really effective. What was I going to say about that? They, yeah, right. So they're not really conditioned to assess themselves. It's more of an obligation to not contest the formation of an LID in the future if it gets to that critical mass that Planner Olson's describing.
Right, it's a waiver for an LID, yeah.
Well, specifically a non-remonstrative agreement, correct?
That's right.
Yeah.
So yeah, that is sort of what the city would do in a circumstance where it might not make sense to have the improvement constructed immediately. So just to sort of cover the different, street improvements that we would require, this is a table from the Transportation Systems Plan currently. So you can see, it depends on, the street designation on which the property is located. And you can see that there are many different factors that go in. So if there's parking on both sides, parking on one side of the street, et cetera. So there's different factors that we take into account, at least within this clear and objective table, that can help sort of provide some sense of guidance as to what the city will be expecting. It's not just kind of coming out of thin air. These are our street standards here. So yeah, this is the idea in certain areas on a neighborhood collector. This could include a bike lane, so you'd want to make sure that there's sufficient paved width, right-of-way, just everything is designed accordingly. So this is something I don't need to, I can go into all the detail if you want, but I'm happy to answer questions about just to give you a general idea of how this works. And this is an existing table that we use to administer this stuff. So I would also point out that we, as a part of this proposal, would include a pathway for applicants to reduce the amount of mitigation that's required for their development. And if they can make an argument that it's not roughly proportional, they can apply through a minor development process to find that either they have to prove that either there is existing infrastructure there and that the that the mitigation would be unnecessary or not proportional in that case, or that, again, it would not be an appropriate time to construct that improvement. And again, this would be where we might go down the route of establishing an LID or other type of assessment similarly. So this would be sort of the discretionary track, if you will. If you think about the ministerial mitigation process being clear and objective, this would allow for more discretionary level of analysis that we might require for a typical minor development. So this would be another sort of route that people could take if it was appropriate. And that wraps up just the very sort of initial concept. You know, we're currently working on, or I should say, staff from different departments is coordinating on a draft for the code amendments here. You know, we have been trying to relatively fast track this in the sense that we would like to have this process set up and ready to go, but we also want to take the time to discuss it and make sure folks understand. But, you know, we have been given direction essentially to move this forward as quickly as we can. So.
Thank you, Eric. We have two questions, Chair, Commissioner Heap.
Yeah, can you explain a little bit more on the mitigation reduction process? Is there any conditions that they would have to make to go through reduction process and go through a minor development process, or do they just say, hey, I feel like, you know, the amount of mitigation required is excessive and I want to go through the minor development process? And so there's no conditions then for them to, you know, move forward with the minor development process. Is that correct? Or is there some type of review that has to be done and met to say, okay, yeah, we see what you're saying. We feel like there is maybe too much mitigation being asked for, therefore, is it unconditional or conditional?
So I guess when we talk about conditions, these are, I think what we're talking about is actually criteria, I guess, you know, so just when we're talking about conditions of approval, conditioning authority. So this is kind of, you know, this wouldn't be applied just to minor development, right? But anyway, just in terms of just whether or not it would make sense for an applicant to go through this process, you know, we have established that they would have to sort of make an argument based on there's already enough infrastructure or it doesn't make sense to do it right now. You know, I think maybe showing that there's existing infrastructure is a little bit more straightforward than saying whether it's an appropriate time to construct the infrastructure, but those are the criteria that we've considered right now. Again, this is still kind of under development in terms of what the process, particularly this component of it, would look like. But, you know, it would have to be after we've, you know, required something of them for their ministerial development, then they would come and say, hey, I think this is a bit too much, and then we could, you know, go through a minor development process. So, you know, we could get a lot of those, but, you know, I think, you know, our approach is that we're essentially doing the same thing that we've always done in terms of the level of improvements that we would require. We're just doing it through a different process. So we, of course, want to provide an out for folks if they don't agree with our determination, but we don't we are optimistic that we won't get, you know, a huge glut of these appeals or, you know, minor development, I guess, reductions, if you will. But you never know.
If staff could make a decision to see the criteria for a minor development has not been met and therefore minor development process will not be offered, staff could make that decision by evaluating the criteria?
No, I think we'd have to go through the process to
But that would be
review the
costly to
application, and you couldn't just
applicant.
reject it without accepting the application or anything. But
I think the goal would be to have a set of criteria that are, of course, clear and objective, but provide, you know, very specific direction in the areas where the exaction or the improvement's not appropriate. Okay, so like to the extent that we can define the, you know, the site conditions in the context that Eric was describing, where making that sidewalk or pathway connection is not timely, then, you know, if there's no existing sidewalk within some certain distance or something like that, if we, to the extent we can codify that, then then no one has to go through this process of asking for a reduction or an exception. I think we're going to get to a point, though, where it'll require that sort of safety valve where people can make that request and it does go through a public process. So that's what we're aiming for anyway.
Yeah, and again, you know, the idea is that we'd basically be imposing the same standards that we do now, and it's actually kind of simplifying the process. But yeah, you know, we have never done the specific, you know, release valve, if you will, so it would be a bit untested.
We have a question from Commissioner Rigby.
So what is the source of, as I understand it right now, the ministerial process is basically just submitting a form saying this is what we're doing, and, you know, then that gets rubber stamped. Is that somewhat accurate?
It requires a lot more than just a form. It's a whole building permit application. So there's a huge, packet of construction drawings and architectural drawings and details that are usually required. So it goes through the process that I was describing where they come to the counter. It's not a discretionary decision, but it does involve review for compliance with the applicable criteria. So we do review and say, do you meet your setbacks? Do you meet your building height, et cetera, from a planning department point of view, and that's how we ensure that zoning is, being adhered to within the city, and that's, planning's kind of role in that process, but it also involves review from buildings, engineering department, public, well, it depends on the project, but a lot of different sort of departments that weigh in, fire department, for instance, when it comes to issues of access. So it's not just a form and a rubber stamp, but it is the typical process that we use, to approve single-family dwellings and just under a building permit.
And is the source for all of those standards by which the application is judged the code, or are there? So, would it be accurate to say that because what it sounds like is currently a certain class of development, exterior modification, single-family, that is currently governed by the code is essentially being switched into being governed by standards created by city staff. Would that be correct often?
Now, this is, so what we're talking about is really you can think of it as a module that we're adding on to an existing process. It's our building permit process, essentially. So, single-family homes, duplexes, today or prior to middle housing, accessory structures went through a building permit process that had no land use review. Planning department reviewed building permit applications, as did building, engineering, and fire. And the standards that apply to those building permits are in the development code, which is the planning commission's purview. They're in the building code. There are fire code requirements that are administered by the building department, and engineering standards for things like street openings or utility connections, undergrounding of utilities, that sort of thing. So what we're talking about is creating really just making public improvement standards apply, making those applicable through this building permit process for types of development that previously would have had that, we would have had that opportunity through the minor development review, the land use process. We don't have that anymore because middle housing is ministerial. So we're talking about a module that are public improvement standards that are applied through this ministerial process, and then where there's a request to reduce it or waive it, it would essentially go back through a minor development process to make that judgment.
But what is the source of the public improvement standards?
Oh, that's a good question. You want to talk about that?
Yeah, the public improvement standards are based on the city's transportation systems plan and generally just the engineering code. There's numerous chapters of the city code that apply to engineering. So we're basing it off of the city's plan for roadways and sidewalks and those types of improvements that was developed. I think it was 2014 was the last update, but I could be wrong.
Yeah, there are 4 public facility master plans. There's the transportation system plan, last updated in 2016. There's a stormwater master plan called the Clean Streams Plan that has similar set of standards and policies. And there's, of course, a wastewater master plan, which tells us where sewer lines go and the sizing of those, where pump stations are needed, and then a water master plan that has a similar set of standards for potable water.
Well, just what I'm looking at here is I see that currently, this is a great way. It seems like a great way to combat the problems that HB 2001 is creating, and to offset some of the stress of the development onto infrastructure. And it looks like what's being proposed is to kind of recreate the current system, but under, in a legal way in terms of what's being imposed on different kinds of development. But in the future, if those public improvement standards change, then some of these classes of development, like the external modifications, the single family, could then be subject to some mitigations that, from which it was totally excluded in the past, a month ago. Would that be accurate?
I don't see how that could happen. Again, it's really taking our existing processes and kind of placing them from minor development into the ministerial process. So, we, even if there is a change to the TSP, that doesn't necessarily mean that we're changing the applicability of, basically requiring these mitigations for ministerial development. It would still apply as it does today. Ministerial development, you'd have to go through a building permit if it was just an exterior modification, something small. But, there's not necessarily, we would still apply that ministerial process, but yeah, the specific improvements that we would require would be based on the TSP. I couldn't imagine a situation where they would, within the TSP, say all development needs to do X and X and X. They could say, this is the standard that we're holding things towards, but it wouldn't necessarily change the applicability of when we would apply those standards, if that makes sense.
The standards for a particular street could change, through the legislative process. The Planning Commission reviews the new transportation plan, and the City Council adopts a new plan that calls for a pathway on a road that never had a plan for a pathway. And now we're applying the same criteria, the same ministerial process is pointing to a different vision or a different plan for that street than what had existed previously. So, they're all connected. Plan policies are implemented through codes, and we're just working on the code right now.
Yeah, a change to any of these plans wouldn't necessarily change the process that the city uses to determine whether or not we would require a mitigation for a single family or duplex, if that makes sense. It would change what those mitigation could look like, but we would still apply it to the adding of the density based on the process that we're proposing in the code.
And
it would be in the code.
And the reality of this is that, additions, remodels, single-family homes, whether they're new or they're a replacement home, duplexes, accessory dwelling units, all of that development is at a level that is so low that we're not anticipating that it's going to trigger any kind of exactions or improvements, but that's for you to help guide us and direct us on through these code amendments.
Thank you, Eric. We have two more questions from commissioners. Commissioner Mitchell?
Yes, on page 6 of the memo that was sent before the meeting, there's a line that says the maximum extent of development mitigation for the site would be known. And I couldn't fully understand, how do the developers know beforehand what the development mitigation is going to be or cost? Really, my line of questioning is, what's it going to cost?
Well, I think the cost of it is a good point. We aren't necessarily, I'm not an expert at that, but we do have the stable here, and we do have the plan where we could say, listen, what street are you on? What are you proposing? And we would, be able to tell them pretty specifically, as opposed to the minor development process currently, where it is sort of, at least from the developer's perspective, a bit of a black box where they make an application and then, we sort of do our internal review and then tell them what they have to do in order for that to be approved. At least we'd say, here's the sort of expectation for what will be required for you, and it would be more clear and more objective.
And through the prior system, the minor development review, you had the benefit of a pre-application meeting conference where a lot of this was maybe not costed out, but at least prescribed in terms of you can expect to be required to make a half-street improvement that includes this much pavement for travel lane, this much for shoulder, this much for a pathway, and it's going to be a curb gutter, or it's going to be a swale. So, at that point, the prospective applicant, and their engineer would go back and start costing it out. Then they would check in with the engineering department. Have we assumed the correct specifications? But we're not going to have the benefit of that pre-application process to vet it and to help provide direction. That's why it's really important that these requirements are really prescribed and and defined in the code. So
yeah, I think we'll have handouts. We'll have the code itself that we hope to make as clear as possible. But yeah, I think our intent is to make that clear. And yeah, I'm not sure that our pre-application conference is really a black box per se, but it is a process where it's a little bit less just here's a paper and you can take a look and figure it out. So thank you.
Commissioner Phillips? Oh, Commissioner Stewart, I'm sorry.
Well, I go by both.
Okay. Hey, you.
So, So I think we can assume, can we not, that when we're talking about these improvements for ministerial development, whether they're, you know, improvements to the street, sidewalk, pathway, whatever, would happen within the boundaries of the property, right, along the street frontage, and then if it's on a corner, it would possibly be on 2 street frontages. Would there be any situation where a requirement should be made beyond that? Like a flag lot or something like that?
You know, I think that there have been instances of that, but I don't think that.
But generally, it'll
Yeah.
happen like within the frontage of the property, right?
Yeah, I mean, that's been something we've achieved through conditions of approval previously, but I don't see, I mean, it was something for, you know, multifamily residential, which has a lot more density being added to a site. So I'm not sure that it would ever rise to that level with the middle
We're talking
housing.
about a level of development that is probably not any more than 8 dwelling units, right? That's a cottage cluster. And then everything above 4 units or everything larger than a quadplex presently, we go through the minor development process where the city could, you know, require off-site improvements like what you're talking about. But just historically, you know, you think about the larger subdivisions that we've seen and the size of the properties that are available for development, and there isn't really anything that is, you know, on a residential sort of, you know, context that's large enough that's going to trigger, you know, a traffic signal 3 blocks away. You know, when we do downtown, even when we do downtown redevelopment, which is not what we're talking about here, you know, you're not seeing a lot of off-site improvements. You might see some traffic signals that are, you know, the timing is changed to accommodate future.
Yeah, I guess maybe I wasn't thinking to that degree of impact, but more of like if you're at the end of a dead-end street, maybe you have to extend the road, or if I said you're on a flag lot, you got to extend the pole or the flag to get to your, you know, property, that, you know, that sort of thing.
We wouldn't imagine, well, typically if it's a flag lot proposal, they have to do that just to comply in the first place. But the,
Right.
you know, I've seen instances where a multifamily development that's not on a major street corner was required to provide a sidewalk connection to that street corner, for instance. But that, you know, these are big multifamily developments, and this is based off trip generation. So if we're talking about essentially no more than 8 units, it's hard to imagine, yeah, that would be the type of exaction required. But again, this is, you know, we're trying to make this as clear and objective as possible. So,
but that something like that would be within, I guess what I'm trying to describe, within the boundaries of your property, you know, so from one side of your property to the other, all the frontage that's kind of in between. So if it's on a corner, yeah, you know, that's within your, technically within the fringe of your property. So that would be part of your required improvement.
yeah, I think just anything that's beyond, you know, what we would see in the table here, you know, we wouldn't be able to, beyond what we have in the code and the sort of references, we wouldn't be able to require that or condition or mitigate, I guess, accordingly. But we would still, you know, its potential, I guess, is what I'm trying to say, is that for minor development, that could be a possibility where we'd require off-site improvements as well. Not for ministerial under our current proposal, though.
Got it. Thank you.
Apologize if that was unclear, but yeah, there's lots of different context-specific circumstances to consider here. So it's very difficult to think of the scenarios because there's a lot of different things that could sort of come into play in different street designations.
Yeah, and I'm just trying to brainstorm as I'm sort of listening to this to kind of better understand it myself.
Senior Planner Olson, is there further information you're going to share with us this evening?
You know, I just wanted to mention that we have a few next steps that we had envisioned. So we were planning, you know, of course, we'd like to hear your input here, but we were planning to bring this to a hearing at the Planning Commission in October, the first meeting of October. And shortly after, we were planning to go to the council with a study session and a hearing at City Council. So I believe the date would be the 10th of October that we would have been proposing the hearing. So that would be the next step, as long as you're comfortable, I guess, and don't have sort of concerns that would require further study.
Commissioners, do you have any further concerns?
One concern I would have is just a little bit with the processes we were talking about. And when we started going into the discussion on like local improvement districts and kind of those non-remonstrative type of clauses, I've always been concerned it's the developer who's passing it down to the road to, unknowing buyers. And so as we went to a public hearing, I'm not sure how to do it. I don't have a great answer here, but, how do you solicit those type of buyers to give feedback on, what their thoughts are for, them taking the responsibility for an LID and non-remonstrative agreement? It's like we don't hear from them. And I don't know if there's any way to solicit that type of feedback in a public hearing, but I've always thought it would be good. Somebody could come in and, the future owners or whatever could say, yeah, this is not a good practice. They could give input on, what is a fair process? Can there be some type of, a disclosure that's done up front that they're made totally aware that there's a lid in place there, and that, at some point in time, they may be, responsible for doing a mitigation or exaction. So that would be my only concern. I don't have any great answers from you, how we'd solicit that type of input from the community.
Yeah, the way that the LID waivers are recorded is with the county. It's officially recorded, so.
Part of their title report that they get when they purchase the property.
Right, so I mean, it is part of due diligence of a new property, that if you're going to purchase it, just look at the tax records and you could find this legal document theoretically, but, it would certainly be nice if people knew more about that.
Exactly, yeah. My experience has been like, even with HOAs, nobody even goes to the deed and looks at, the CCNRs and things like that. So it's kind of a surprise, but I guess, that's correct. I mean, it's kind of the buyer's due diligence to go and find that out. I just wish there was a better process, yeah.
There's a bit more of a relationship with the city, so, I mean, the fact that the city is a party to the agreement, at least, so, I'll consider that if there's ways for, in the process for folks to be reminded of that, or to, it wouldn't be a recorded plat, but if there's some way to sort of, make that pop, I guess, in the record, I'm not sure what that would look like, but.
I think, one thing to consider with that is that these projects are really going to be, if they ever come to fruition, they're going to be, these pockets that are within a much larger corridor, or a project where, the city's got a major capital improvement project to improve, Lakeview Boulevard, and so there are places along Lakeview Boulevard that have pathways, and there are other places that have nothing. And then there are places that are developing, and they're large enough to develop that they can actually provide the street improvement that's required by the standards, and others that are not large enough, and they agree, not to remonstrate against a future LID. So the way that a project like that comes together is through a public process, the city, reaching out to the community and saying, hey, we're trying to prioritize our CIP, and, creating a budget every 2 years. Looks like it's time for Lakeview Boulevard. I'm singling out Lakeview Boulevard, but there's a lot of other streets that we could talk about where I understand, you're buying a piece of property, and hopefully you look at that deed and you see that there might be a zone of benefit on there too, or you're actually on the hook to help pay for a sewer that the developer, paid for years ago. So I think part of it is regulatory, but a much larger part of it is communication and just the city working with the residents and the property owners.
And I agree with you. It's going to be a limited amount of this going on in our city, but I will tell you, I saw a listing that came across my feed this week the first time. And in real estate, there's public comments that you see and Zillow sees, and then there's private ones that realtors only see. And the private comments said, this property qualifies for middle housing. You can build a triplex, fourplex, and it was a $900,000 piece of land. And I think it was on Lake Grove Avenue.
I think I saw that, actually. That was public.
Was it?
I
Well,
think so, yeah.
everything goes public, but there you go. So it may happen, or someone might just, build $1 million house or $3 million house. I don't know, but I'm beginning to see that people are aware that it's a possibility.
Absolutely, yeah, we've been receiving some calls with folks just kind of asking, like, what can I do with my property now? I'm just kind of wondering what their options are, but yeah, nothing that I've heard that's been very concrete, at least not yet, so,
Well, it's early on.
yeah.
Any other questions or comments, commissioners?
Just gonna maybe go back and answer Eric and staff's question. It was, yeah, I think my opinion is that we're ready to go to hearing. The suggestion in October seems to be fine. So my recommendation would be to go forward in October.
All right, thank you.
Fine. Thank you very much. Good presentation.
Great, thanks for the direction.
I have a little bit of housekeeping that I need to take care of. We had a motion and a second to approve the minutes of June 13th, but we did not vote on them. So all in favor of approval?
Aye.
I need to abstain because I was not at the meeting.
Okay. And so I guess the people who are approving it have approved it. Thank you. And then we have any other business that we need to attend to this evening? Don't see a lot of people here raising their hands. Schedule review?
Thank you, Chair Leak. Your next regularly scheduled meeting is August 8th, and you have a work session scheduled to review an initial list of the annual Community Development Code amendments for 2022. And then your next meeting after that, on the 22nd, you'll be touring the Palisades neighborhood, or at least a portion of the neighborhood, that the neighborhood association is exploring the possibility of developing an overlay zone. And the last time we met, I think I asked about the meeting time, and it sounded like 5 p.m. was comfortable for folks. Hopefully it's not
That's
100
what
degrees.
everyone seemed to be comfortable with.
Okay, so we'll make sure the agenda includes directions. I'm not sure where we're meeting up with the neighborhood association, but we'll find a suitable location, and then any members of the public who want to join you for that meeting will be able to, meet with us there. I'm not sure if it'll be a driving tour or a walking tour. Kind of depends on the geography that they want to talk about.
Super, thank you. I guess,
Excuse me. I wanted to make a point that our next meeting on August 8th is a remote-only meeting, virtual, due to court having a jury trial.
right.
Thank you, Iris.
Thank you, Iris. So without any further business to address, do we have a motion to adjourn?
Make a motion to adjourn.
Second?
I move.
All in favor?
Aye.
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 Great, thank you very much. See you on August.